Considering all the relevant facts and circumstances before court, the court makes a value judgment and finds that the applicant failed to put exceptional circumstances justifying his release on bail. As I have highlighted, there are a number of very concerning aspects, not only linking the applicant to the crimes, but also regarding his circle of influence and capabilities. His application for bail is accordingly refused.
Hello everybody, welcome back to this channel. Hope you're doing good. Today inside the Alexandra Magistrates Court, all eyes were fixed on Magistrate Rainer Boshoff as the fate of Katiso KT Molefes hung in the balance. Today's question was simple. Would Molefe walk free on bail or remain behind bars until trial? The answer, delivered with a striking clarity, was bail denied. Molefe, accused of orchestrating the assassination of popular musician Oupa DJ Sumbody Sefoka and two of his bodyguards in 2022, faced the most crucial test in his long-running battle with the law. Under the South African's bail laws for serious offences, the burden was on him to prove exceptional circumstances that justified his release. But according to Judge Boshoff, Molefe failed to do so. The state evidence painted a picture of coordination, secrecy, and influence. Cell phone records placed Molefe and his co-accused at the same areas at critical times. Large sums of money appeared in accounts around the time of the killings, and WhatsApp messages revealed Molefe's role in arranging bail for others. Messages ending with words like, "This is evidence of what teamwork can achieve." The judge stressed that this was not coincidence, it was a pattern, a web of calls, payments, and messages that suggested Molefe wasn't just an associate. He was a central figure in the operation, and with such influence, the risk of interference with witnesses or even further violence was simply too great. On top of that, Molefe already faced serious charges in other murder cases, including the killing of Aman Swart and DJ Vintos. He had previously been granted bail in Pretoria, yet here the magistrate concluded that the gravity of this case changed everything. Molefe was deemed a danger to society and a flight risk. And so, with the weight of the evidence and the absence of exceptional circumstances, Magistrate Boshoff denied Molefe bail. He will remain in custody and return to court on the 18th of September 2025, where he and his co-accused are expected to face formal indictments. The case is far from over, but for now the court has spoken. Katiso KT Molefes stays behind bars. Please tell us your thoughts down in the comment section, and don't forget to like, share, and subscribe. Don't forget to watch all those ads.
Thank you. The matter was postponed to today for court to deliver judgment on bail application. Thank you.
Mr. Molefe, the court accordingly proceeds with judgment. It is common cause that the applicant has a pending case for the murder of Philip Armand Swart. Now, it's a pending case in the sense that it's pending in another court. This person was shot and killed on 17 April 2024. Now, the same co-accused, to wit Michael Puli Tau, Musa Kekana, and Diego Floyd Mabusela, are involved in all these cases with the applicant. The applicant is further charged with the following counts in this case: conspiracy to commit murder in respect of Oupa Sefoka, DJ Sumbody, murder in respect of the same person, conspiracy to commit murder in respect of Sibusiso Mokoena, murder in respect of Sibusiso Mokoena, conspiracy to commit murder in respect of Sandile Sean Mieza, conspiracy to commit murder in respect of Hector Butelesi or DJ Vintos, murder in respect of the same person. The applicant on appeal was granted bail by the High Court on the first matter currently pending in the High Court. It is alleged that all these killings were contract killings. The allegation is that it involves a similar modus operandi. The victims were killed in assassination style with AK-47 assault rifles with the clear motive of elimination. These killings also involved the actual contact killers, accused 1, 2, and 3, where the case against them appears to be extremely strong at this stage. It also involves a mastermind and or middleman, the one orchestrating the hits. It appears that the applicant, according to the state, falls in the last category. Now here it is alleged that the victims were involved in a drug trade, the applicant's personal circumstances are before court. The applicant, sorry, I just want to say, you indicated last time that there was no need for interpreter. That's still the position. The applicant was born in Mapetla, Soweto. He completed his matric there and studied at Vista University. He lived in the Greater Johannesburg area for his whole life. It is significant that the applicant has a previous drug-related conviction in the UK for the possession of drugs, cannabis, the import of which is prohibited, as it's stated on the UK documents. He also has a fraud conviction relating to his stay in the UK. What is really concerning is the fact that he used a false Lesotho passport, in that case together with a false name or alias to wit David Tebo Lebica. Now, although this was way back in 2004, it raises concern of what the applicant is capable of. It appears that the investigative unit currently investigates other cases of similar nature against members of this so-called syndicate, and that there are missing pieces of evidence like the other AK-47 assault rifle used in these murders. Another concern this court has is the large amounts of cash that were paid into the applicant's company's accounts. This, in the absence of an explanation, strongly suggests unidentified sources of income with the risks that goes together with that. The applicant avers that the state's case against him is extremely weak and circumstantial by nature. It is true that the evidence against the applicant, because of his role in the killings, will be distant, as he was not physically present during the hits. The absence of direct evidence, however, does not mean that an inference of guilt can't be deducted. In the Matabula case, it was ruled, but a state case supposed in advance to be frail may nevertheless sustain proof beyond reasonable doubt when put to the test in order to successfully challenge the merits of such a case in bail proceedings. And the application needs to go further. He must prove on a balance of probability that he will be acquitted of the charges. Now, this in its essence means that in bail applications, because of its unique character, admissibility requirements are less stringent in bail applications than in the subsequent trial matters because of the initial nature of bail applications. The other accused, for instance, are not before court, and only the trial court will have the benefit to rule on the evidence in its totality. The applicant alleges that he is neither K nor Pafa. The state adduced evidence based on cell phone records, WhatsApps, and calls made from number one, especially that applicant is both gay and Bafa. It is quite apparent that the gunmen were awaiting payment from the applicant, according to this, for these hits performed. It is significant that accused 1 and 2's phones were picked up at the cell phone tower near the applicants on the very same 24th day of November. On this day, accused number 1 also deposited 100,000 rand cash into his account, with number 2 and 3 also depositing cash into their respective bank accounts. Now, what is extremely relevant here is number 1's address is in Roodepoort, and that of number 2 in Atteridgeville, Pretoria. That's a relatively far cry from Sandton, where the accused lives. The cell phone records after these so-called hits between the respective accused are indeed very interesting. Accused 1 frantically trying to reach the applicant moments after the Sandton hit on DJ Sumbody. He made no less than 8 calls to the applicant. Accused 1 also contacted the applicant after the killing of yet another DJ, the Orlando matter. In all these cases, cash deposits follows. The state alleges that the state witnesses fear for their lives after his initial release on bail. The applicant made several assurances regarding number 1's bail application. Now, on the 15th of July 2024, he sent a message to accused number 1's wife saying, "Appearance for bail application today. Next court appearance, bail will be granted for him." On the 2nd day of August 2024, the applicant sent a WhatsApp message, "Bail granted," to which the friend replied, "Good work, my brother." The applicant responded, "This is evidence of what teamwork can achieve, my brother." Now, although bail was granted in High Court regarding the Swart case, this court is of the respectful opinion that a lot has changed since then. The current counts are indeed of a very serious nature and can definitely increase the risk to abscond. Very importantly, the evidential link between the 4 accused persons in this case appears to have increased. Bail proceedings are sui generis in that it involves several considerations. The freedom of the individual, his right to be presumed innocent or proven guilty, the interests of justice, to name but a few. There is also the statutory framework requiring that the accused must, on a balance of probabilities, show the existence of exceptional circumstances to permit his release on bail. In the Dlamini Dladla Hubert Skietekat decision, the Constitutional Court ruled that exceptional circumstances require something out of the ordinary to be established before an accused charged with a Schedule 6 offence will be granted bail. Now, considering all the relevant facts and circumstances before court, the court makes a value judgment and finds that the applicant failed to put exceptional circumstances justifying his release on bail. As I have highlighted, there are a number of very concerning aspects, not only linking the applicant to the crimes, but also regarding his circle of influence and capabilities. His application for bail is accordingly refused.
Court, please.
What is the date? Was it 26 August?
No, it was 18th of September. 18 September.
18 September.
18 September.
For the other accused.
For the other accused.
Mr. Molefe, 18 September. It's a provisional date for the indictment and you will be kept in custody.